Hi, are you having difficulty in keeping up with the latest immigration developments? There's a lot of news about their entry into the US, about their status violations, and everything else that is being talked about immigrants. So today I'll try to give you a summary of latest developments in immigration law. My name is Remzi Kulen. I'm an immigration lawyer. I've helped thousands of people immigrate into the United States in the last 20 years. I'll try to give you the best up-to-date information about the latest immigration developments. I want to start with green card holders. There's a lot of news about green card holders having difficulty in traveling or entering the US. What is the bottom line in traveling with a green card? First of all, there is no change in rules and regulations. There is just a different interpretation of the law by the current administration. As you know, if you are a green card holder, you cannot leave the US for more than 180 days at any given trip. However, even if you are not spending more than 180 days outside of the US, but you're spending an extended period of time outside of the US, and you're doing this repeatedly over and over, and the time you spent outside of the US seems to be more than the time you spent in the US, then you may be abandoning your green card status or your lawful permanent residency. So what's happening right now is green card holders who are having difficulty in entering the US are those who spend an extended period of time outside of the US. This could be more than 180 days, which could give the CBP officers to question you, to put you on secondary inspection and ask you a lot of questions about why you spent so much time outside of the US. But even if you're spending less than 180 days at any given trip, but you are doing this repeatedly, over and over, so much so that one can understand that you are living outside of the US and not inside the US, you can still be questioned. So that's the thing that changed a little bit in the last few months. Those green card holders who spend a lot of time outside of the US are being questioned. If you're a green card holder and if you have minor offenses in the past, you may also be affected with the last administration application of the rules and regulations. Because minor past offenses, even if they are dismissed, can now trigger more questioning at the port of entry. If these past offenses do not give rise to you being inadmissible, a reason for stripping you from your legal permanent status, you should not worry. You will be let into the United States, but you may have extended periods of questioning at the port of entry. So, if you have been present outside of the US for a long period of time, if you have past minor offenses, you should definitely consult with an immigration attorney before traveling internationally. I would like to bring up the re-entry permit option because it is our favorite application these days. If you're spending a lot of time outside of the US, you can file a re-entry permit application with USCIS. You can get a permission from USCIS to spend more time outside of the US. Think of this as an insurance for your green card. If you want to keep your green card, but you want to spend some time outside of the US, file your re-entry permit application, get it, and travel with confidence. If you have questions about spending a lot of time outside of the US as a green card holder or re-entry permit application, please reach out to us and we will assist you. Another word of advice for green card holders and visa holders alike, CBP can search your belongings, your suitcases, your clothes, your laptops, your electronic devices, and they have the right to do so. If your electronic device is password protected, then you don't have to provide the password for it. But if you don't, they may want to access it on their own, and this may take a very long time. So you will spend a lot of time at the port of entry. So our advice is to travel with clear devices and also cooperate with the CBP authorities so that you can have a pleasant travel experience. It's important to note that non-citizens have fewer legal rights than US citizens and green card holders. In the port of entry, you don't have a right to legal representation, so you cannot have an attorney represent you at the port of entry. So you need to be very careful while entering and exiting and the type of information you carry with you at all times. So as a green card holder, there are some things that you can do to protect yourself before traveling. First of all, do not take any trips more than 180 days. Also, file taxes as a US resident. Do not forget filing your tax returns. I see this all the time. People who do not really live in the US while having the green card, who work and live outside of the US, they don't feel like they need to file tax returns in the US. This is a mistake. you are a green card holder and you should be filing tax returns. This doesn't mean that you need to pay for taxes. It is possible that you do not pay taxes either because your income is not at that level, or there is a tax treaty between your country and the US, but you need to file your tax returns. You need to keep your ties with the US. It could be a job, it could be a family reason, it could be school, it could be a lease agreement, rent agreement, bank statements. You need to keep your ties with the US. You can carry documents like pay stubs, bank accounts, lease agreements with you at all times. Clean your devices of private or sensitive content. You can let a trusted contact about your travel. You can carry your attorney's information or a letter from your attorney explaining why you traveled out of US for such a long time. And also do not sign any forms without legal advice. So what CBP officers cannot do is also very important. They cannot take away your green card unless you voluntarily give it up. CBP officers sometimes advise you to sign a 407 form, which is a voluntary surrender of your green card. You should not feel compelled to do this because this is voluntary. If you don't sign that form, they cannot take your green card away from you. Instead, you can ask CBP to refer you to a judge so that you can explain yourself to keep your green card. So if you don't want to give it up, you don't have to give it up. But if you want to give it up, all you need to sign is the 407 form. The CBP officers cannot deport you on the spot. They have to refer you to a judge. You will have an attorney, and the judge will decide whether your green card should be taken away from you. If you want to see a judge or the CBP officers is referring you to a judge, they will issue you what is called an NTA, notice to appear, so that you can appear before a judge and explain your situation. Let me give you an update on the F1 student visa. As you know, there's a lot of status terminations in the last few weeks, and there's also a lot of visa revocations for F1 students. Where is this coming from? It is estimated that CBP has terminated around 5,000 F1 records since January 20 of 2025. 50% of these F1 students are in OPT, optional practical training. The CBP termination amounts to immediate loss of work authorization for those OPT holders, and the termination leads to F1 students not being able to maintain their status. Basically, what the school says in their email to the students is that you do not have any status anymore. Please leave the US immediately. And some students received an email from the consulate where they applied for their F1 visas that their visas were revoked. First of all, we need to understand that these two things are different. If your CBP record is terminated and you're receiving an email either through CBP or from your school saying that your status has been terminated, that means that you do not have any status in the US and you need to leave the US. That's what that means. If you're receiving an email from the consulate saying your visa has been revoked, that means that you cannot enter the US with that visa anymore. But if you're in the US, that visa revocation does not affect your visa status. That's why this is very important. If you're receiving a status violation email, your status is terminated and you need to leave the US. If it's just the visa revocation email from the consulate, then your visa is revoked. You cannot enter the US, but you can remain in the US. What is very unusual is in the last few months, most students are receiving both of these emails within a few days of each other. That's what's concerning. So what are the common characteristics of the students who are receiving these emails? There seems to be two common risk factors for those students who are receiving these emails. The first one is any police interaction, any DUI charge in the past, any speeding ticket, a fight in the bar, wrongful arrests, even domestic violence issues. If you had some kind of an interaction with the police in the past, this seems to be the triggering factor in terminating your status or revoking your visa. The other common theme seems to be the political activism, especially politically charged or anti-Semitic content may result in these revocations and status cancellations. It seems like AI-based surveillance is scanning for prohibited expressions online. I'm saying prohibited in quotation marks because there's supposed to be a freedom of expression in the United States and it applies to everybody in the US. So this political activism part is very open to interpretation. So let's say you're an F1 student and you received a notice from the school saying that your CBP record is terminated. What are your options? The first option seems to be the reinstatement application with USCIS. Reinstatement application is to request USCIS to reinstate you to the F1 status. So this is an application filed by USCIS. It is USCIS who actually terminated your status. So it may seem like a mood application, but that application is also the application which keeps you here for the time being. So maybe it is best to file for a reinstatement at any given time, just to prove that you did everything you could possibly do to be here. The second option would be to request a CVIS data fix, either through DSO or through CVIS. If you could do that, and if you can fix the problem, then maybe you don't need the reinstatement. So this might be the first thing you want to do. The third option would be to challenge the NTA in the immigration court if there is an NTA. So there is not always an NTA. NTA is notice to appear. You need to come to the court, show up for the court. We're trying to cancel your status, but we canceled your status and now we're trying to deport you. So if you are issued an NTA, you should definitely fight with it at the immigration court. The fourth option would be to sue the government in federal court. This sounds scary, but seems to be a very viable option. Actually, I've heard a few attorneys who filed these federal cases at the district court were able to get an injunction so that the status violation was put on hold and the students would be able to continue their classes until the case is being adjudicated. So this seems to be a very effective way to get an immediate action. So I recommend you consult with an immigration attorney who does this, who can litigate in the federal court for you. The fifth option would be to leave the US and come back on a new F1 visa. I don't think this is a great option, because if you leave and you apply for a visa at the consulate, they will already think that you have violated your status. So the chances of getting that visa would be very slim. The sixth option would be to apply for a change of status within the US. Again, this may be a little bit difficult because USCIS already thinks that you have violated your status. So if you violated your status, it may be very difficult to change the status. So these issues with F1 students seem to be ongoing and there's a lot of developments. You definitely need to consult with an immigration attorney about your options before moving forward. What you don't need to do is remain inactive. You have to be very actively inquiring about this, trying to find a solution to your situation, but do not ignore it. It can be very dangerous. Another important development in immigration in the last few weeks was the data sharing agreement between ICE and IRS. Why is this significant? Because IRS never shares information with our other government agencies due to privacy concerns and laws regulating the privacy of the taxpayers. So up until now, for example, if immigration had a question about your tax filings, they would send you an RFE and you would prepare what you have and send it back to USCIS. USCIS would never get in touch with IRS and ask for tax documents from IRS directly. It would be you who would provide this information. Right now, ICE has approached IRS and asked if they can get information about the people who they are investigating or who they are trying to remove from the United States. This is significant because IRS for years encouraged unauthorized, undocumented taxpayers here in the US to file tax returns and that their tax filings would not be shared with the immigration. This allowed a lot of undocumented immigrants to file for tax returns and contribute to the US economy. If now they provide this information to ICE, it would discourage people from filing tax returns. As far as we know, no information has been shared by IRS yet. But if IRS agrees to do this, then people who are in removal proceedings or people who are being investigated by ICE might be in danger. We will monitor the situation and we'll give you updates as we go along. But if you are in legal status or in the process of applying, this doesn't seem to affect you because, like I said, ICE is reaching out to IRS, not USCIS. And ICE is the enforcement agency of the Department of Homeland Security. USCIS is the benefit adjudicator. So there's no agreement between USCIS and IRS at this moment. One of the most recent developments in immigration is the new registration requirement for non-citizens. Effective April 11, 2025, all non-citizens in the US must register their presence in the United States. They now have a special form for this. It's called Form G325R. Those who need to register include non-citizens aged 14 and up without previous biometric registration, parents and guardians of undocumented minors, those who entered without an inspection or aren't listed under any visa categories. So that kind of tells you that there is exceptions to this requirement. Indeed, some non-citizens are already considered registered and they don't need to register. These include green card holders, anybody who entered the US with an I-94, anybody who was issued a US visa before entry into the United States, anybody who are in removal proceedings, anybody who were issued an EAD, or applied for a green card using forms I-485, or have a border crossing card. But if you have entered without inspection, then you would need to register. This is serious if you need to register, because if you don't register, then you can be subject to fines and even jail time. The registration form asks a lot of questions, including your background and criminal activity. So if you registered and you admit to any criminal activity, this could also potentially lead to ICE detaining you. If you are one of those who need to register, you are having difficulty in completing the form, you definitely need to consult with an immigration attorney as to what your options are and how to complete the form. Probably the last immigration development I want to talk about is the parole termination notices for CBP One users. The Department of Homeland Security sent out parole termination notices to people who entered the US using the CBP One program during the Biden administration, entered the US with an humanitarian parole. We are talking about close to 1 million people in the United States who entered the US CBP One program. So the Department of Homeland Security now tells them to leave the US within 7 days. In other words, self-deport yourself within the next 7 days, unless you have obtained another immigration status. So if you've received one of these emails from the Department of Homeland Security, you need to check. If you haven't filed for anything yet, then you need to be very concerned and you need to talk to an immigration attorney. If you've already filed for a TPS, or if you've already filed for an asylum application while your court proceeding is going on, then you may be protected, and you're generally protected until the court decides what it's going to do with your case. So Trump administration's effort to send these notices and ask people to self-deport themselves, again, instills a lot of fear in these applicants. If you haven't filed for anything, if you don't have a TPS, if you didn't file for an asylum application at the court, if you don't have a removal procedure, then you are under danger. But if you have TPS, if you have a case pending with immigration court, then you may be protected until those applications are being resolved. So you need to definitely talk with an immigration attorney under these circumstances. I've tried to explain you what's going on at the immigration world in the last few weeks. There's a lot of things that I tried to summarize. There may be things that you don't understand, or there may be things that I didn't touch on and you have questions on. Please drop a line on the comment section below and I'll try to respond them as much as I can. So please subscribe to our channel and turn on the notifications so that you can be notified when a new video comes up. I hope you liked the video. I'll see you in the next one. Take care.